quite a bit of material in this week, and it just serves the foundation for our exploration and introduction to the law in the rest of the course. So far we have been covering a lot of topic material. It is necessary for what we're going to do, and in these next 2 weeks, 4 and 5, which can meld together, we're really going to start digging into how the law works and how we can apply it, learning some real skills that you can use in business. Because there is so much material here, I am actually going to try and chop it up a bit in these podcasts. So there might be a few of them, but hopefully they're smaller and more digestible. So the first thing that we actually want to look at here is introducing law in the Australian legal system. So yes, we want to understand why law is relevant to business, but we also want to understand what we mean when we're talking about law and the different ways of actually classifying the law. We're going to look at the sources of law, which includes dealing with the issue of the doctrine of the separation of powers. And then we're going to look at different legal systems throughout the world as part of our introduction to the law. So by the end of this, hopefully you'll be able to understand the various classifications of law and what the separation of powers means, understand and be able to distinguish the two main legal systems that we have in the world, civil systems and common law systems, and understand the broad elements of the Australian legal system. There is some reading required. I'm sure you've all seen that. Now, law is relevant to business in lots of ways. I'll let you read the text, etc. It affects everything that you do in law. While it can be seen as an impediment to doing business, gets in the way of doing deals, it's actually really important because it upholds bargains that we make, tells us how to do the things like marketing and advertising the right way, how to safely produce products, etc. So critical to business. In terms of the subject matter of law, it can mean lots of different things, lots of different times. So we can look at what's regulated by law. Traditionally, there have been two categories of law, public law and private law. When we look at public law, it's about the relationship between the law and the law as it applies to society versus individual to individual. So with constitutional law, it's about the rules governing our states and federal government, so the state in the general sense of the word state, and the citizen. Administrative law is things like how the government, the executive arm of the government, actually administers to make sure that that's fair to everyone. Taxation law, how they raise money, criminal law, what's an offence, you get the idea. These are all areas where it's the relationship between the citizen and the state. In contrast, the private area of law is dealing more about the relationship between individuals within a legal system. And there are many different aspects to this private relationships that we have that are governed by the law. And you can see some of them listed here. Tort, which includes, say, negligence, stuff like that, contract law, competition law, owning property, the law of commerce, your employment, and how we govern corporations. These things are about the relationship between individuals rather than the individual and society. And that's how we make a big separation in the law. So, public law, concerned with the relationship between the citizen and the state. Private law, concerned about the relationship between persons within the community. Not only can we classify things as public law and private law, we can also classify law as criminal or civil. Criminal's about criminal stuff and civil's everything else. Case law as opposed to statute, and we went through that last week. I won't. And we'll touch it again as we go through because these distinctions are talked about for a reason. They're important distinctions. And even within case law, we have common law as opposed to equity. We'll get into that in a minute. So criminal law, that's where the state's punishing a person for breaching special laws called crimes. And we have differences that come into the law when we have these different classifications. So if we have something like a criminal act, then the standard of proof is beyond reasonable doubt. Now contrast that with a civil law action where it's not about a crime and imprisoning someone, then the standard of proof is on the balance of probabilities. So is it more likely than not? And civil law is about actions brought by an individual against another, and the emphasis is on remedies, nearly always on damages, although there are instances of what they call specific performance or injunctions under equity. We'll talk about them in more detail. So you can see criminal law quite different to civil law in many respects. And so here, if we look at the difference, say, between case law and statute law, we can see that case law, as we know, is made by the judges under the doctrine of precedent, something we'll come back to and talk about as part of this 4 and 5, most notably in areas of contract and tort, which is where we still use case law a lot. Statute is law made by Parliament, and it's through passing legislation. Often it confirms or reaffirms common law principles and then adds a bit and can modify them and or replace them. Consumer protection is an example of that we do in week 10. Really critical to understand. If there's a conflict between statute and case law, then the statute prevails. The idea being, statute is made by people who we elect, so therefore the laws they pass are the will of the people, versus case law comes from a judge who isn't elected. So therefore we should allow the statute or the legislature to change the law that judges have actually made because it's the will of the people. Okay, another area where you'll see this distinction in the law is between common law and equity. This goes back a long way in history, but originally when the courts were around, one of the problems that started to occur was that because of the nature of the doctrine of precedent and judges being bound by those of a higher court and previous decisions, is the law became very inflexible and it could actually lead to some very tough decisions. So as a result of that, people would appeal from that, and in those days they'd appeal to the king directly. And the king could dispense, and sometimes the king mainly, but sometimes the Queen, would then dispense justice through the Court of Chancery. And that became a whole area of law, the Court of Equity. Like the name suggests, it was more about justice. And out of this idea of the Court of Equity came some ideas or principles. Some judge-made law and principles as those courts got bigger and bigger because the King or Queen couldn't see everyone, so they got some judges to do it. Out of that became some principles and the rules of equity. Not only were there some principles which allowed for more just decisions, but we also got some different kinds of remedies. So whereas common law was about damages, in equity you could get some other remedies like injunctions, which stop people doing something, or specific performance, which actually makes them do something. And so sometimes damages are not enough. Like if you destroy a piece of virgin environment, you can never get that back. And so we have equity, which allows some remedies which are not damages, where damages wouldn't be the right, wouldn't put you in the position that you would have been in if you had won the case. And in those instances, you can get specific performance and injunctions. For our purposes, law, just be aware of that final distinction between common law and equity. In reality, the two courts have been brought together or fused in the late 1800s. So now the one judge dispenses both principles of law. But it's an interesting fact to understand.